Who is entitled to be the executor or the personal representative of a Florida estate? Hello, my name is John P.L.L.C. I'm a Florida probate lawyer in West Palm Beach, Florida with the P.L.L.C. law firm. We handle disputes, trials, and lawsuits involving wills, trusts, and estates, as well as probates and guardianships. We also handle litigation regarding commercial and business disputes, appeals, and related disputes and trials regarding bank accounts, life insurance, contracts, and financial accounts. I'm going to speak to you for just a moment on Florida Probate Code Section 733.301, preference in appointment of a personal representative. Here in Florida, probate lawyers and judges and the whole probate bar refer to an executor of an estate as a personal representative. The judge issues an order empowering someone to serve as the personal representative of a Florida estate, and also issues letters of administration. These letters grant the authority to that person to go ahead and administer the estate. In granting these letters of administration, there is an order of preference that is supposed to be observed in evaluating and appointing someone as the personal representative of a Florida probate or a Florida estate. Florida probate lawyers know that 733.301 is often very important when there is no will. Somebody dies without a will in Florida, and the court has to decide who's going to administer the estate if the parties or the interested persons or the heirs cannot agree. And also in the context of family fights, when somebody is appointed in a will to administer the estate, but somebody else doesn't believe that that person is fit or should administer the estate. So you can look at Florida Probate Code Section 733.301. And remember, the Florida Probate Code is a list of statutes. It's different than the Florida Probate Rules. So in granting letters of administration permitting someone to serve as the personal representative, there's an order of preference that should be observed. Where there's a will involved in an estate, the personal representative or his or her successor nominated by the will, right, pursuant to a last will of somebody who passed away in Florida, that's given the highest priority or the highest preference. Next, the person selected by a majority in interest of the persons entitled to the estate. Third, a devisee under the will. If more than one devisee, or a devisee is somebody who obtains an inheritance or is named to receive an inheritance under a Florida will. If more than one devisee wants to administer the estate, the court may select the one best qualified. And there's also a provision here for intestate estates. When somebody passes away without a will, who's entitled to preference to serve to administer that Florida estate? The surviving spouse is at the top of the list, the person selected by a majority in interest of the heirs, and then the heir nearest in degree. And you can read more about who should be entitled to a certain preference in the appointment of a personal representative by reading the Florida Probate Code Section 733.301. When you're involved in probate litigation and inheritance trials in Florida, understanding who's entitled to serve as personal representative or who may have a preference to administer the estate is often a very important factor. Thank you, and this concludes my remarks about preference in the appointment of someone to run a Florida probate.